Hello, I'm Locke Meredith with the Legal Lines. We're going to have on the show today Danny Atkinson. He's a defense lawyer here in Baton Rouge with Atkinson, Perry, Atkinson, and Bauhoff. And we're going to talk about the defense perspective and the plaintiff's perspective. So join us. We'll be right back on Legal Lines. Hello, I'm Locke Meredith. This is the Legal Line. Thank you for joining us. Today we have on our show Danny Atkinson. He's a defense attorney here in Baton Rouge with Atkinson, Perry, Atkinson, and Bauhoff. Been a defense lawyer for a bunch of years. Danny, it's great to have you on the show.
Thanks for inviting me.
Let's talk about the difference between the perspective of the defense lawyer, which primarily you've done for the last 14 years or so, and the plaintiff side, which I'll represent. All right?
Okay.
Tell me about how you get involved in a case.
Well, the majority of the time, Locke, we represent insurance clients, insurance companies, and their insureds. Insureds are people who buy their insurance policies. If someone's involved in an accident, they usually will turn a claim or matter over to their agent who gets it to the insurance company. The insurance company will refer defense of the insured and or the company to a defense attorney.
Let me stop you. The insured. The insured isn't just the person who buys that insurance policy, is he?
Not necessarily.
He can be a guy who's been given permission to get in that car and drive it around, or he could be a passenger in the vehicle.
That's right.
Right.
Usually a policy will have a named insured on it, and then it'll have additional information. If it's a policy on a house, a homeowner's policy, maybe the husband, the father is the named insured, but the policy will also insure the children living in the house and the spouse.
So you guys represent the interests of anyone who's covered under that policy.
That's correct.
Now what happens if I say, look, you know, somebody got hurt at my house or in my car, and I want you to cover me, protect me, and you say, hey, buddy, there's no insurance here. At least that's the position of the insurance coverage. What happens then?
Well, if the company, if there's a problem with coverage or they foresee a coverage defense under the terms and conditions of the policy, what they'll do is they'll refer the defense of the company to one lawyer and the defense of the insured to a separate attorney, because at that point there's a divergence of interest, a conflict of interest.
You couldn't represent both.
That's right.
Okay. And so the insurance company hires one lawyer to represent the insurance company and one lawyer to represent the person who says, hey, I got coverage under this policy.
That's right. And for instance, a situation where that might arise would be if an insured got into a fight with someone and hit somebody and injured that person. The policies, most policies have what's called an intentional act exclusion that says that if you hurt someone by way of an intentional act, you're not covered for that. But there are a lot of nuances to that, because there's some case law that says, well, it may have been an intentional act, but depending on the language of the policy, if the damage that occurred was not what was intended, then there may be coverage. But at that point, there's still a conflict, and you would need two attorneys.
Okay. Now, it's interesting, coverages provided by insurance policies. If I buy an insurance policy to cover me in my car, but I use my car and I'm actually doing a job at that moment, there may be an exclusion in that policy that says you need a whole different insurance policy, doesn't it?
That's correct.
And that stuff pops up pretty often.
And that's why people should read their insurance policies when they get them to make sure what's covered and what's not.
So let's say I got a client. He's been rear-ended by your client, okay? I file a lawsuit, and the insurance company refers it to you. What happens next?
Well, at that point, what you would get would be the initial investigation by the insurance company. They have what people call adjusters, and they have investigators who will do an initial investigation of the accident, the claim, try to collect medical. Usually, by that time, there may be an attorney involved for the claimant, potential plaintiff once the suit is filed. And they'll send that information to me with the pleadings that have been filed.
Right. Normally, when I represent someone, Generally, the client's gonna treat for whatever period of time is required. Then we'll get the medical records together. We'll accumulate the facts, the police report, and we'll put together a settlement package. We'll send it to the adjuster. The adjuster's kind of doing the same thing, collecting information and looking at what we send them. But if we can't meet eye to eye, and I go ahead and file a lawsuit, they send all that info to you eventually.
That's right. Once a lawsuit's filed is when I'll become involved. I'm not involved in the initial investigation. And it's nice for plaintiff lawyers who do what you say, who prepare these settlement packages and send them to insurance companies. They love that because they need the information in order to evaluate the claim.
What happens next? You guys have to file an answer on behalf of your clients.
That's right.
And then we have what's called the discovery process.
Well, getting back to the answer, you have a certain limited amount of information, and when you file your answer, if there's some defenses, you need to raise those in the answer.
Now, what does that mean? Folks aren't going to know what you mean, defenses.
Well, under our system of law, there's something called affirmative defenses, and you have to raise those. A defendant must raise those in his pleading so that the other party is on notice of any defenses you may be raising. An example would be fault of the plaintiff.
There's some boilerplate defenses, aren't there?
That's right.
You guys, I know I've gotten answers from you guys a lot, and it's basically pretty much the same ones in every answer. What are they?
That's true. Fault of the plaintiff, fault of a third party, but that's not necessarily true all the time because the plaintiff may have been a guest passenger in a car, and certainly he couldn't be at fault for the accident. So you wouldn't want to raise it in the answer. Some people may as a boilerplate answer, but it shouldn't be done. But there are others, and the code requires that you specifically list those in your answer, because if you don't and you go to trial eventually, if the plaintiff lawyer is smart, he's going to object if you try to put on any evidence of that defense, and the judge is going to sustain that objection, and you're not going to be able to put on the evidence.
And then the job goes from getting written documentation to really eyeballing folks and talking to them face to face, isn't it?
That's right, and most of the time, plaintiff lawyers will allow adjusters to take what's called recorded statements, either over the phone or in person, after a claim is filed. But these are not under oath. These are just question-answer sessions that are taped. When the lawyers get involved, they want to take what's called depositions, where you get these witnesses under oath, where there's some
just
penalty.
like testifying in court.
That's right, and there's a penalty if you don't tell the truth, and that way, hopefully, you'll get the straight and narrow. But many times you see a divergence between what was said in a statement and what's said under oath in a deposition.
So I've always told my clients when the defense lawyer is getting ready to depose them is there's two reasons for that deposition. One is to find out what happened and look at you and listen to you and watch you and see if you look like you're telling the truth. And the other is to hold you to the story. Because once you say something in that deposition, if you try and change your story at trial, they're going to beat you over the head with that deposition and say, hey, remember when I asked you that question? Is that pretty much the way it is?
That's right. And there's other reasons. There's procedural reasons for taking depositions, because we have dispositive motion practice in Louisiana law, which means we don't have to go all the way to trial in certain cases, because we may be able to file what's called a motion for summary judgment. If there's no dispute of fact, you can file a motion and maybe get the case dismissed short of a trial. The judge would make that decision.
They can either resolve a narrow issue, for example, liability. Judge could, via the depositions that I might take of your client, I may take his deposition, ask him how the accident occurred. He'd say, hey, man, it was all my fault. Now, I'll file a motion for summary judgment for the judge to decide, hey, there's no issue here. The guy's at fault for the collision. So then the only issue is damages.
That's right.
And then on the other side, you can do the same thing.
Right, and our code requires that you put on evidence either by deposition or affidavit in support or opposition to the motion, and that's why you'd want to maybe take the deposition.
After taking depositions, a lot of times it moves into what we've talked about, which are the motions that are filed in preparation for trial or in advance of trial.
Right.
How do you decide which ones you're going to file?
Well, that's a lengthy question.
Well, why don't we do this? Let's talk about that when we come back, and talk about the motions that are filed by you and I in advance of trial to help narrow the issues for the judge or the jury. This is Locke Meredith with The Legal Line. We'll be right back. Thank you for joining us back here on the Legal Lines. I'm Locke Meredith. I have with me today Danny Atkinson. He's a defense lawyer here in town. And we're talking about the different perspectives of a defense lawyer versus a plaintiff lawyer. Danny, we were talking about the motions that you'll file, that I'll file, in advance of the trial to help kind of narrow the issues before the judge or the jury. Let's talk about those. What do you look at?
Well, we were talking earlier about motions for summary judgment. There are other motions. They're called exceptions. When you first get a case in, the suit may not have been filed in the proper venue.
Meaning location.
The location, and that could be important in a case from a defense standpoint and from a plaintiff standpoint. There are certain parishes where juries tend to be more liberal on.
And you don't like that.
And a defense lawyer would not like that, and of course plaintiff lawyers would. The code provides for the locations where a suit can be filed based on domicile of the parties.
Meaning where they live. Or where the accident happened.
Where the accident happened. If there's an insurance company involved, usually East Baton Rouge Parish is a proper venue.
If it's a foreign insurance company.
That's correct. So if there's an improper venue, because you look at the allegations of the petition, you may file what's called an exception of improper venue. It may be jurisdiction. The court may not have jurisdiction over that person or the subject matter of the lawsuit. And so that would be the first thing that a defense attorney would look for. They may not have a cause of action.
Meaning claim.
Right. A minor can't file a lawsuit, and you can't sue a minor in Louisiana. You have to be over the age of 18.
The parent or their legal guardian is the one that's supposed to bring it on their behalf.
That's right. So if you get past all of that, and then we talked about motions for summary judgment, and you may not file a motion for summary judgment initially in the litigation. You may take depositions, and you may not see a certain issue until you depose other witnesses who may have been named in a prior deposition, and at some point you discover, hey, I've got a defense here, and we've got this testimony. You may file a motion at that point.
And you can file more than one motion for summary judgment.
That's right.
On different issues.
Well, you can even file it on the same issue if new evidence comes to light.
Right. A lot of times the judges will set up what's called a status conference with the judges, and they'll actually set deadlines by which we have to complete all of the collection of the information, taking depositions of folks, and actually file deadlines by which we've got to complete whatever motions we're going to put in front of the court.
That's correct.
And that's helpful, isn't it?
And that's that's the rules in the federal court. In the state court, it's kind of in the discretion of the judges. We're trying to get that changed to have the same rules for every district court.
Make it a little easier, wouldn't it?
Yeah.
Let's talk about the jury trial system. What do you think of it?
Well, the jury system is the best system in the world. You hear that all the time. There are a lot of people that come out of jury trials who aren't happy, and I've been in that position before.
Me too.
And a lot of people who come out happy, and a lot of times both come out either happy or unhappy. But it is the best system. It's the fairest system. In Louisiana, in a civil case, though, I mean, you can only have a jury trial if the damages, there's no dispute that the damages are going to be greater than $50,000. If it's going to be less, then it's a judge trial.
And what's so interesting is we've had judges on the show, and they're elected to this very important position with a whole lot of power, and yet when those jurors are sitting in that jury box, they have as much power as that judge. I mean, it's amazing what our society has come up with on how to resolve disputes between people. What do you find to be any weaknesses with the system?
Well, one weakness I felt all along was, and I guess this was just tradition, but supposedly every citizen should be subjected to having to serve on a jury. It's a civil duty. But historically, lawyers, doctors, professionals would get a subpoena, and they could call a judge or someone or jury coordinator, and they could get it taken care of, saying, look, I can't spend a week. I've got patients to see and that type of thing. Those rules have changed. The Supreme Court has made it clear that everyone has to serve. And matter of fact, I had jury service last year. I didn't get picked on a jury, but I sat around.
Well, let's explain that. Why there are challenges that each lawyer has. You have a certain number of challenges as the defense. I have a certain number of challenges as the plaintiff. And if a juror's up on, or a potential juror is called up on the panel, we ask them questions, and we can either challenge them for cause, which means there's a legitimate reason why we feel like they shouldn't be a juror, or we can challenge them without cause, but those are limited.
Right, and
And why do we go through that dance, that song and dance?
Well, that's called voir dire, and that's how the lawyers can try to iron out those people that they think would not be the right jurors for their particular case.
Of course, you're looking for folks that are going to be very conservative or find that there's no liability, and I'm looking for folks who I think are going to be sympathetic to my folks' side.
I wasn't going to say that, Locke. I was going to look for jurors that are fair, but no. I mean, if you question the jurors are under oath and voir dire, they're sworn in, and you ask, and you got to be careful because you don't want to get one mad that may still end up on a jury. You got to be careful with your questioning. But for instance, I had a case a year ago where it was a brain damaged young child, and I asked all the jurors. I said, I'm going to ask you to walk out of here after giving this child a 0, and can you
Meaning
do
no
that?
money.
No money, and can you do that? And there were several that said under no circumstances could they do that.
So you challenged them for cause.
Right, and one on some and did not on others. But it's important for jurors on voir dire to be honest and forthcoming. Just because they're not picked doesn't mean that they're a bad person or anything. Right. It just means that the lawyers don't feel comfortable with them on that particular case.
And we're laughing about what we're focusing on, but the bottom line is you're right, and that is we do want a jury that is going to be fair and apply the law based on the facts and evidence that's presented to them.
That's right.
And it's so interesting, I know you've seen it in your practice, and I have, the range of positions or decisions that can be made.
Right. I mean, there's a vast amount of discretion placed in on a jury, especially in terms of damage awards. And the standard, if you appeal a jury award, is called an abuse of that discretion. And the courts of appeal are not inclined to change jury verdicts on awards unless it's just blatantly outside the range of what has normally been awarded for that type of injury.
Well, and what we have available is if a jury renders a verdict either in your favor or in my favor that either of us feels is unreasonable, we can ask the judge to rule contrary or different than that jury, and that's called a...
That's your first bite at the apple to try to change it. You can file a motion notwithstanding the verdict with the judge, or a motion for what's called an additure to add to the damages, or remediature to reduce the damages.
So it's, we'll try and have the judge fix it at the trial level, and either he'll add to the damages if he feels like the jury awarded too little, or if he believes that the jury awarded too much, he can reduce it. Or let's say the jury found that there was no liability or that there was liability. If he disagrees with that and thinks the evidence is just overwhelming, then he'll change that decision.
That's right, and that's always a difficult decision for a judge. And like I said before, with the courts of appeals, it's the same for the trial court judge. I mean, the majority of the time, they're not going to be willing to change a jury verdict unless there's just something that's blatant, where it's just a total abuse of discretion, or on a liability issue where they just didn't follow the jury instructions correctly, and it was clear that it doesn't hold up.
Well, let's talk about that, the jury instructions and the difficulty sometimes that gives a jury, and even us as lawyers. We'll do that in just a minute. This is Locke Meredith with the Legal Lines. We'll be right back. Thank you for coming back. This is The Legal Line. I'm Locke Meredith, and I've got on the show today Danny Atkinson. He's a defense lawyer here in town, and we're talking about the defense perspective versus the plaintiff perspective. Danny, we were talking about the jury system, and we started talking about jury charges. What are jury charges?
Jury charges are nothing more than statements of the law that the court will read to the jury after all the evidence is presented. The attorneys have to rest their sides of the case, and then the judge will read the jury instructions, which is the law that applies to that case.
Let me stop you, because we don't always agree on what the law is in that case, do we?
We normally don't.
So what we do is, plaintiff lawyer submits his proposed jury charges to the judge, and you guys do the same thing, and then we have kind of a little hearing where the judge decides what he believes to be the law on that issue.
That's right, but most judges have what's called a standard jury verdict or jury instruction form, because most of the law is pretty vanilla, you know, Hornbook law, and that they're not going to change that. It's usually what we call special jury instructions they consider, because in this particular case there's some issue that you don't see every day, and there's been law by, you know, decisions of the courts that have addressed it, and you try to get the judge to agree to your jury instructions.
And it's interesting because we have several different appellate courts, and there will be decisions on the same issue by one court that differ from the other court's decisions.
That's true, and normally when you have a conflict between two circuits, the Supreme Court might take it up and decide that issue, but a lot of times they don't. So you have conflicts, and in that case, usually the court will accept the prior decision of the circuit in which it belongs.
Which in our case is the First Circuit Court of Appeal. So if we have a conflict between the First Circuit Court of Appeal and say the Third Circuit Court of Appeal, the judge in the 19th Judicial District Court, and of course there are other district courts that fall under the First Circuit, are going to follow what the First Circuit Appellate Court judges said the law is.
That's right.
All right. What experiences have you had with the jury system trying to educate a jury on the law in a paragraph?
In a paragraph?
I mean, the jury charge.
Well, you know, most of the time, you've never seen a jury charge that is a paragraph. The judge normally has about 10 pages he's reading, and by the time he gets to the 6th, the jury is starting to nod off. But
and when I'm saying paragraph, each specific area of the law that he's talking about might be a paragraph or a page long.
That's right.
But you're right, there can be 20 pages.
Depending on the case. Depending on the case. But, I mean, once you submit your jury instructions and you argue it out with the judge, it's his decision, and that's what's going to be read to the jury.
Well, and you know what's interesting is we have the ability, you on the defense side and me on the plaintiff side, to educate the jury as to what that jury charge is going to be and what it means in closing argument.
Right, and a lot of times it'll already be decided before the trial begins with the judge what the jury instructions will be, and a lot of times I'll use the jury instruction in my opening statement saying when this trial's over, you're going to be read this jury instruction, and I want to read it to you because I want you to think about it as you hear the evidence, because then they can put the two together ahead of time.
It's interesting because we have the big view or the big perspective. We know the whole system and how it's going to work and put the pieces of the puzzle together, but the jury doesn't really always have that big picture, and it's our job to make sure that they kind of know what the big picture is and how the process is going to go and help them as best we can.
And that's why I think opening statement is probably as important, if not more, than your closing argument to the jury, because you're giving them an outline of what you're going to prove, and you better stick to your outline.
They remember what you tell them, which is good. And I tell you, another really positive development in this jury system that we have is that they can now take notes.
That is a good feature. I thought that was a good decision.
And because years ago, they had to remember it all, and that's impossible.
Nobody has that attention span in our society today to sit through a week-long trial to remember everything every witness said. If they have notes that they can take, then they can go back and refresh their memory.
And compare them.
That's right.
I think that's a wonderful development. Let's move from that and let's talk about settlement and mediation of cases, because as you and I know, probably 80–90%, if not more, of cases settle. And so that's an important part of this whole judicial system. Tell me what your experience is in the settlement area.
Well, alternative dispute resolution is becoming more and more popular now. We have so many lawsuits filed that the courts certainly couldn't hear every case. There's just no way. And so we have alternatives set up, mediators who could be lawyers, some are not lawyers.
Judges too, retired judges.
Retired judges who will get together with the parties and let them argue their cases and let them brief it to them. And then he can go back, he'll separate them at some point in caucuses and then go back and forth and try to get them to some common ground to get the matter resolved. Insurance companies are very interested in mediations.
I think it's a wonderful thing. Of course, you know, before we start the litigation process, as I had indicated before, generally we'll put together a settlement package, we'll send it to the adjuster, hopefully reasonable minds will prevail and we'll reach a settlement. but oftentimes that doesn't happen. So when we get in the litigation system, just because you file a lawsuit doesn't mean you're going to trial.
That's right.
And we go into the process that you've described. I have also found it very useful. I find that being able to get the parties who involve sitting face to face at the same table with their representatives is very important.
It is. It is.
The process, let's describe the process in a little more detail. Generally, we'll show up, there'll be a mediator. Now, this guy isn't going to force anybody to do anything, is he?
Right. There's something called mediation, and then there's something called binding arbitration, which is a mediation, except the mediator ultimately, by agreement, is the judge. The parties agree that whatever he decides they're going to live with, and they sign an agreement to that.
Now, they've got to agree to that.
They've got to agree to that.
Nobody can be forced to do that.
That's right.
Now, oftentimes that's in a contract, isn't it?
Right.
But that's generally not what you and I go through.
No, what most settlements occur through either just negotiations between the parties or mediation, formal mediation. And what the parties would do would agree on a person, a mediator, who would mediate the case. They normally would have their attorneys outline the case in a brief to send to that mediator. They call them position statements, position papers. And the mediator will hopefully read those before he meets with you, and then you will sit down. Plaintiff will give his side of the story in a sort of like an opening statement.
And it's good because I will have my client sitting with me, and I will sit there and present their side of the story in a very forceful way, and he's there and he knows that I'm doing what I'm supposed to do. He also hears you do the same thing.
Right.
And you're, of course, going to point out the weaknesses that you perceive in the case. I point out the strengths. And then what happens?
Well, he'll go back and forth, and what happens is the plaintiff will make an offer of, I mean, in our system, it's money. I mean, that's how our system of laws works in a civil case. You know, you can't put the person back in the position he was before an accident, so you pay him money damages.
So we go in separate rooms.
All right.
And then after we've given each of our positions with all the parties present, the mediator will go back and forth between the plaintiff side and the defense side, and he'll kind of explain their positions and discuss it in greater detail and do the same.
That's right. Sometimes mediators lose weight because they walk back and forth so much. But
it works, doesn't it?
Yeah, it does.
I'm very pleased with the way, because frankly, when the mediation process first came out, I thought, this is nuts. I can accomplish this, but I found mediation to be wonderful. Tell you what, I think we're going to plan on the next show to maybe have a mediator on to discuss this in greater detail from his perspective. But thank you very much, Danny Atkinson, for being on the show.
Thanks for having me.
And we'll have you again. This is Locke Meredith with the Legal Lines. Thank you for being with us.